Administrative appeals office that reviews all of your appeals that you pay a ton of money for, their job is to play backstop to the agency.
Welcome back to Visa Vibes, the podcast where we attempt to bring some clarity to U.S. immigration law, one episode at a time. I'm Emily Newman, managing partner of Reddy Newman Brown PC.
And I'm Stephen Brown. I'm also with Reddy Newman Brown PC. And today we're going to step into the courtroom today, a little courtroom drama, but not what most people think about when they talk immigration court. We're going to talk about federal court litigation and immigration benefits litigation. We're not talking removal or detention or anything like that. We're going to talk about suing the government when they take too long, when they break the rules, or when they make improper decisions. It gives us that backstop for those types of things.
Yeah, and as an immigration attorney, I've really never set foot in a courtroom. I'm not a litigator for sure, even though I've been doing this for 20 years. The closest thing we used to do to litigation is threaten litigation when the Houston field office would be taking too long on some N-400 naturalization applications. But we never actually went to court until the Trump administration, the first Trump administration. Then, we're seeing USCIS, consulate stalling cases. We're seeing mishandling of paperwork, wrongly denying applications, petitions. And back then, our common remedy was file a motion to reopen, file a motion to reconsider, or file an appeal to the Administrative Appeals Office, or refile. But when things are super expensive, when things take longer, there's no processing times that are reasonable, those remedies aren't really remedies. And so we started looking into taking USCIS to federal court under something called the Administrative Procedures Act.
Yeah, and you bring up the Trump administration, and really there was some employment-based and benefits-based litigation prior to the Trump administration, if you go look into the history, but it really started then. People got wise. There were a couple of attorneys that came out of the government and started telling people, like, the Administrative Appeals Office that reviews all of your appeals that you pay a ton of money for, their job is to play backstop to the agency. They're going to look for any ways to support the agency's decision. But let's be clear what we're talking about here today when we talk about litigation and court. There is immigration court with an immigration judge. He's really he or she's really a Department of Justice employee, but they're called immigration judges, and they do deportations, they do removal, they do asylum cases. This is not that. We are talking about civil litigation in a federal district court against USCIS, Department of Labor, other Homeland Security entities, sometimes Department of State, ICE recently. And this is before an Article 3 judge. This is a federally appointed and confirmed judge that is a neutral party on these cases.
Yeah, now one thing to be really crystal clear about is these lawsuits are not meant to get the court to tell the immigration service to approve your case. Judges are not going to do that. What we do ask the judges to tell the government, hey, do your job, or stop taking so long, adjudicate this application, or stop using a policy that violates the statute. So the judge can tell the immigration service or whatever the agency is to hurry up and make a decision, but the judge is not going to tell them what decision to make. Sometime in the event of denials, they can tell the government your denial is unreasonable, arbitrary, capricious, not in line with the statute, and so then USCIS will reopen. They could turn around and deny again under a different reason or make a better denial argument. So that's kind of the limits of litigation, is you can't force an approval.
No, and really, the judge will tell them, when I ask in our prayer of relief, it's always, let's talk a denial case, set aside the denial, so like it never happened, and order them to reopen and re-adjudicate. Maybe it's reopen and re-adjudicate generally, or reopen, re-adjudicate without this policy that we've argued is unlawful. But it is just that set aside. They can't say, you need to go approve this case. Now, I've had judges say it, in court, like, what do we need to do to get this person their documents? But they don't really have that authority, and they know it. But what we call this is typically APA litigation. And again, um, when we talk about where to sue, it's kind of interesting. The venue statute, when we talk about where to sue, it's venue. And it's either where the individual resides, the company or the individual, because there's never any real property involved. We can sue there in that district court. We can sue where the government is headquartered, DC, Maryland. There's reasons to and to not go, although that's kind of pivoting a little bit, or where the events took place. So um, if you live in Florida, and Miami, Florida, and the Texas Service Center is handling your 485 case, we can either sue in the district court there in Miami, we could sue in the Northern District of Texas up there where the Texas Service Center is, and theoretically in Maryland, although for delay cases, usually I try to avoid Maryland. Judges aren't a huge fan.
All right. So you mentioned this is APA litigation. That stands for the Administrative Procedure Act. This is a law that's been around since 1946, and it sets the rules for how any federal government agency has to operate and make decisions. So it's not just specific to the immigration agencies. But under this law, courts can basically set aside agency actions that are arbitrary, capricious, and abuse of discretion or otherwise not in accordance with law.
Yeah, and you mentioned it's any agency. One of the big cases, and we'll talk about it later, was against the FCC that we use for delay cases. But um, not only the denials, but they have to act in a reasonable amount of time. Now, what is reasonable? We'll talk about that later. But there's a lot of things we look to. I mean, there's certain statutes that say, if it's beyond 6 months, maybe we can sue. Now, some cases we got to kind of be a little bit more flexible on. The 485s, a little bit longer, but an EAD, that's been pending for 6 months, like that's probably unreasonable on its face.
So we've used the APA, and I say we.
You've been involved, Emily. We've done it.
I'm not, but Stephen and partners that we deal with have used the APA to challenge policies that are inconsistent with statute or regulation. This things like denying H-1Bs based on made-up standards, or requiring EADs when employment authorization is supposed to be incident to status. There was some not regulation, some policy guidance that was put out that really wasn't based in any regulations, didn't go through notice and comment. So those are the kind of things that we can challenge.
Yeah, and so let's talk about your case is sitting too long. There is a lot of jargon that goes into this, and some attorneys will call it one thing when it really means another, and some call it one when it means something else. And mandamus, writ of mandamus, or APA delay case. And I can tell you, I get so many messages like, I want to file a WOM, writ of mandamus. And there is a distinction between the APA delay and writ of mandamus. And largely speaking, they mean the same thing. The client really doesn't care the method as long as we can reach an approval or
Yeah.
adjudication.
Yeah, so the APA is one thing. A writ of mandamus is really an extraordinary legal remedy. It's used to compel a federal officer or agency to perform a duty that they are legally required to do. So, in plain English, hey, judge, force the government to do what it's supposed to do, which sounds kind of like an APA.
Again, this is where we get a lot of interplay between the two, and some attorneys call it, because mandamus, it sounds fancier, and it's more people see, when they Google it for SEO and all. But to win a mandamus, ultimately we have to show a clear, indisputable right to relief, a clear duty by the agency that they have to act, and no other adequate remedy available. Now, there are some courts that have said, if we're talking about a delay case in the immigration context, the APA is an adequate remedy available before we get to mandamus. Again, there are plenty of attorneys out there that I have a lot of respect to that on their website it's mandamus, and they're doing APA litigation, but it's what's more familiar to people.
Yeah, so because it's kind of considered an extraordinary relief, courts tend to be a little bit more reluctant to grant it. So that's why in most immigration delay cases, we tend to rely on the APA, Administrative Procedure Act, which allows a court to compel an agency action that has been unreasonably delayed.
Yeah, and what courts tend to look to, and some courts are going to have a different case that they look to, but really the primary case has created what are called track factors, TRAC factors. Courts use these factors based off of a case. It's Telecom Research and Action Center versus the FCC to decide if a case is unreasonably delayed under the APA. The number one track factor that is always going to be looked at in all of these cases is there a rule of reason? And so, is it logical? And typically, the response from USCIS is we do things generally in a first in, first out basis. And um, that's not always the case. There's a lot of data to support that, or they'll argue, look at our processing times. That we're well below that. And sometimes judges bite off, the line jumping or the first in, first out, even though it's not really a line, some judges bite off. But when it comes to the processing times, there's a lot of cases that have said those aren't, definite, right, in terms of whether it's reasonable. In fact, there was an appellate court, and I can't remember if it was the fourth or the sixth, because there were two decisions, similar benefit types around the same time, that said we're really not going to look at the processing times because we're not going to compare snails versus snails in a snail's race. And their argument was all of the processing times could be unreasonable. I mean, if USCIS gets on and updates and says 100 years, is that reasonable just because they've got it on their website? Number two track factor is congressional timetable. So if Congress has set a deadline, the court's going to give that substantial weight. In the immigration context, Congress has spoken to what is aspirational. Most courts have said it's aspirational. I think it's a little bit more definitive, but really, quick timelines, about 180 days for things like your green card. Now, that's a question for interpretation for the judge. Number two is going to be health and human welfare factor. And how does the delay impact the health and human welfare, the livelihood, the immigration status, and comparing that to the harm the agency has to have to process this? And I'm going to tell you, that's when we typically win. It's lost some before on the track three, but a lot of judges are going to realize losing your immigration status, losing your right to work is a bigger harm than you've got to take the 10 minutes it takes to adjudicate an I-765. The effect on other competing priorities that the agency has. So the agency's USCIS sets certain priorities. We want to do X, Y, and Z as an agency. What is the impact of speeding up your case against their other priorities? A good example is there is a part, not all, of Department of Labor that is tasked between perm and H2 visas. And they go back and forth, and H2s are more fast and time sensitive. And so if we sued on a perm delay and hey, that team happens to be over there now, it still shouldn't be as long as it is. But that's that. Now, what is the prejudice of the delay? Again, kind of what your harm is, losing work, travel limits, age out, stuff like that. And then the one that's in the case is the agency intent. We don't have to show bad faith. But if there is a delay because of bad faith, it is per se unreasonable. So there are things to look at, but it is a balancing act.
Yeah, so the courts do have to take this track factor to really balance an immigration context, the complexity of the immigration system, how many different types of applications and different areas that USCIS deals with, and then put that against the real life consequences that flow to the clients that are filing the lawsuits due to these delays. So we do almost always, cite the track factors in any APA delay lawsuit, even if we have a mandamus claim in there as well.
Yeah, and we've also done, we aren't talking about it as much today about unlawful withholding. There are certain things under the statute that are, the INA, that are mandatory. And so, again, we will address all those. So, what kind of cases can you bring? And we've done a whole bunch of different things. You go look at my litigation folder, Emily. Now, I want to talk, before we get into what do we do, every case is going to be unique. It is hard to sit there and generalize. If you're at X, it's unreasonable. There are some that I think we can do that, but let's talk about delays first, Emily.
Yeah. So one is I-485 applications for the green card, specifically when the priority date is current. So if your date's not current, you can't sue to make them give you a green card because there's not one available to you. But when the date has been current and just no action is happening, we've been able to do that, as well as the benefits that go along with a pending 485. So EAD applications based on that C9 code for a pending green card application. Advanced parole. That's
Absolutely.
EADs are not as much of a problem because the renewals allow for an auto extension. So people usually can get the new EAD card within that auto extension period. But advanced parole, if you get an approval back a couple of years ago, you would get a 2-year document. So you can travel for 2 years. And then you file your renewal, and it takes a year to process. And you cannot travel while it's pending because they will abandon your advanced parole, however they came up with that plan. You could be stuck without being able to travel for a year. What happens if you have an emergency, overseas? So that one was a big one. Yeah. And then we dealt with H4 EAD delays because they didn't have the auto extension.
Right.
And USCIS started separating them, claiming that they had to delay things because of this biometrics requirement that they added and then eventually took away. L2 EADs are having the same problem. I-526 and I-829 investor petitions, EB5 category, those historically take forever to process for no good reason. And then, even though we generally have a hard time with suing Department of State for actions of a consulate, we have been able to sue when there's a delay in a visa stamping.
Yeah.
If someone gets a 221G and their case just sits there for 8 months, that is an unreasonable delay, and we've seen success there.
And what makes those cases so interesting is nobody knows where it's going. The judges, 221G, and we've had a conversation with this by the statute, is a refusal. And some judges will say it's a refusal. That's a decision, consular non-reviewability. We're not going to get involved. There are some judges who are like, no, you have it still processing. That means it has to be within a reasonable time. And it's really all over the place, judge to judge. There was a decision out of the DC circuit that maybe is going to move the needle a little bit, but very wild area. But not just delays. That's always the first thing people think about because it's the most common issue people face. But denials, too, when they apply the law incorrectly, they invent new criteria out of the blue. They don't properly apply the facts of a case. We have done really what started a big boom in litigation as a tool was H-1B denials. There were a lot of memos, a lot of pushback from the first Trump administration on H-1B denials. And we still see it every once in a while, claiming a job isn't a specialty occupation or a beneficiary qualifies for it, even if there's an expert involved. And so those are cases that we can bring. I-485 denials can be tricky because 485s are discretionary and courts don't tend to get involved in discretionary, but when there's true legal questions, they can be broad, especially when we see, especially at the field office, Emily, like they don't always apply the law properly. I mean, we were talking about a 245L issue, with a spouse whose husband passed away. They completely ignored it. Seva's reinstatement, that was big recently. We did a lot on Seva's cases the last few months. And then, policies too. We have gone after policies. We've gone after regulations. We've been part of teams. I'm on a litigation committee and maybe we're working behind the scenes as well.
Yeah, so some of the big successes that our firm has been involved with over the years, one of the major ones was the L2 EAD litigation. So prior to the outcome of this lawsuit, and ever since I've been an immigration attorney, if an L2 spouse These are spouses of intracompany transferees, so they're spouses of managers, executives, or specialized knowledge professionals of global companies, multinational companies. Once they come into the US on an L2 visa, they were told they need to separately apply for an employment authorization card from USCIS and get that approved before they can start working. Well, that's not what Congress intended. Congress didn't say anything about them needing an EAD. They said L2s can work.
Right.
So for how many years we were filing these EAD applications, and it wasn't really a big deal until processing times got delayed. And then all of a sudden we have these L2 spouses that can't work, losing jobs, and it became a big problem. So we were able to change the policy. USCIS agreed that EADs are not required. So an L2 spouse, as soon as they come into the US in L2S status,
Right.
because they changed how they issue I-94s now to differentiate between an L2 spouse and an L2 child, because only the spouse can work. Now they just immediately start working. They can immediately apply for a social security card. So that was a major win.
And they incorporated E spouses too, because they had the same statutory language. We had sued on L spouses because that's who we had been contacted by and we were representing. But E spouses have the same language, and so we had settled on L spouses, and then their policy memo came out for E spouses because it's the same language.
Yeah, and so we also were able to change the policy regarding automatic extension of these EADs, specifically for L2 spouses, E spouses, and H4 EAD holders. So prior to that, you file your L1 renewal, your L2 renewal, your EAD renewal, and if the EAD expires while these renewals are pending, the L1 holder can keep working even though their L1 has expired, but the L2 cannot because their EAD expired and you cannot work based on a pending receipt. Now you can. Now, for H4 EADs, it's a little trickier because you also have to have the I-94 extended, but at least we have some option there because for a while there, people were just losing their jobs unnecessarily.
And that issue came up because their whole defense, when we had argued that they should get the same 240-day rule, is that, well, we can't do it for the EAD because the I-94 isn't extended. And we said, we've got clients, the I-94 is extended. Do it. Whether they traveled or maybe the I-539 gets approved and the EAD, the I-765 keeps waiting. So that kind of bore itself out from the government's arguments to us.
So that was the Shergill case. We also had the Edicuni case. This was a nationwide class action solely based on H4 EAD delays, where we had a lot of data to show that USCIS wasn't going first in, first out. There was no rule of reason. They were just all over the place and they were taking forever. And again, people were losing their jobs. So that did require, as a settlement agreement, that whenever you file an I-129 plus the I-539 plus the I-765 all together and in premium processing, they're considered these bundled applications and USCIS would process all of them together. So as long as you filed in premium processing, you could pretty much make sure that your spouse was not going to lose their work authorization. Unfortunately, that settlement agreement did expire at the beginning of this year. We are still seeing some cases bundled together and getting the approvals together, but we're also seeing some not. So this issue is going to come back up. So we're going to be litigating again. And then you mentioned the SEVIS litigation. These F1 students were just randomly one day told your SEVIS has been terminated because of some criminal records check. Now, some of them had been arrested. Some of them had been convicted for minor crimes, but a lot of them, no conviction, or some of them were even the victim of these things and were
traffic tickets.
Yeah, so Stephen was one of the first lawyers to start suing on that issue. We were able to get temporary restraining orders to block them from taking any kind of negative action against the students because of this unlawful termination. And then eventually they got all of their SEVIS records turned back on and treat them as if it never happened.
Yeah, and we've gotten most of those. There's a few more that we're just trying to finalize settlements on, trying to push a little bit of fees a little bit from the government. But, each case is going to be different. I always, talk when we talk with our team here, like, I can give our team kind of generalization, limits on what we're looking to do, but really each case is going to be unique. Each denial is going to be unique. Each delay is going to be a little bit unique. But litigation can push the government to act in a reasonable manner. And when we talk about denials, the phrase I always use is getting adults in the room. You're going to have a U.S. attorney who's looking at it rather than a line adjudicator. They're going to be talking with agency counsel. So you get adults in the room.
All right. Now, another type of litigation that's available is dealing with FOIA, Freedom of Information Act delay litigation. So it's not something that people think about a lot, but it can be helpful in many situations.
Yeah, this is kind of a fun little pet project I started a few years ago, doing a lot more filing of FOIAs and then litigating the FOIA delays. So, um, FOIA delays, I think, are very important in immigration. There's so much shrouded in mystery. We don't ever see, whether it's policies that we never see, memos we never see, but maybe you need something like your A file or prior decisions, or maybe internal emails about your case to figure out what's going on. And they don't do this timely.
Yeah, so the FOIA statute specifically says if you submit a Freedom of Information Act request, the agency must respond to you within 20 business days. Now, that rarely happens. Sometimes they delay months, sometimes even years. I mean, how many times have you done a FOIA, forgot about it, and then 2 years later, the agency reaches out and says, "Do you still want all of
I
this?"
Yeah,
Yes, we do.
that or I get the CD that
Yeah,
comes to the
yeah.
office. And I'm like, oh, I forgot I did
We're
this
going
one.
back to 1995 with CDs. I don't, maybe even
The-
before that, but
And they have the 20 business days. They can always request an additional 10 for certain reasons, but they don't even do it within the 30. I've told government attorneys, like, if y'all could get it to the 30, my clients will be fine with that extra 10 days. But like you said, we've had this months, years. Where it's waiting. And when we talk about some of this information, it might be time sensitive to your case, or when we're talking about data to put forward to litigation, data changes. So if I get data today that I requested in 2022, it's kind of irrelevant now. And so you can sue on FOIA. And here's what kind of makes it interesting. The FOIA has a fee shifting provision. And what I mean by that depending on the jurisdiction and the case law and how things go, you can, in the lawsuit, request attorney's fees, move for attorney's fees back. And, like I said, this is not just your documents. I've talked to plenty of people who said, we're trying to get the old 485 inventory, the I-140, how many I-140s are there? And they wait 3 years to do it. But we can use this. FOIA is a tool that can be very helpful.
yeah, it definitely helps kind of when we're trying to challenge some of these broader policy decisions and things to have that data and to get it timely because it can uncover some bad agency action, which we can get corrected.
Yeah, and so let's talk briefly. Not a sales pitch, but what do we do on our end? So somebody sends us a thing like, "Hey, I got a delay," or "Hey, I got a denial." What are we gonna do? Well, I'm gonna have a conversation with you. Like, what's going on? What can we do? I had someone today. It's like been 2 months. Their 485 is pending, and I said we need to wait a little bit longer. What's been filed? What's going on? And what benefit can litigation provide? Maybe it can't. There are certain cases we can't bring. But what can we do? And does it make sense?
Yeah, so we're going to assess whether the facts of the case make it strong for a lawsuit. As you mentioned, not every delay is unreasonable, at least not yet. Not every denial is unlawful.
No.
Sometimes they get it right, and so litigation isn't going to fix that. But if there's a clear pattern or some sort of legal flaw, that's something we can generally litigate.
Yeah, a good example. Emily and I were talking today about a denial, and I think procedurally the government got things wrong, but I don't know if we clear up the procedure, the result is going to be the same for this individual. And I want to make sure people understand that. I always tell them, I'm not here to sell a used car. I want you to feel comfortable, and we're going to provide a benefit to you. And so once we get everything going, we're going to draft what's called a complaint. This is the lawsuit. It's going to, an introduction, who the parties are, why we're suing, in the venue and that we're in, and then what are the facts and the legal background, and then what do we want. Um, out of this, and then we're going to file it online through the electronic court filing system. We're going to serve the government. Now it's got to go through the mail, and under Rule 4, we got to serve it through certified mail. Some jurisdictions have email set up, and because we've done this a lot, there are some U.S. attorneys that'll say, "Hey, we're serving you pursuant to Rule 4, but just to give you a heads up, my client's really anxious. Can you take a look?" And sometimes they do. Sometimes they'll wait. And then the government gets 60 days for most cases. FOIA, it's 30, but most cases the government gets 60 days to respond to the lawsuit. Either maybe they're going to work to resolve it, and issue the documents, or they take steps to. I've seen the 485 context. I had one today. They want a new supplement J, or they want to do an interview, and that's fine. We'll work out timelines after that. Or they're going to fight the case, and we're prepared for that. They'll file what's called a motion to dismiss, and we'll oppose and wait for the judge, and then we'll take the next steps in litigation. And what I always tell people, they hear dismiss and they get nervous, is that has no negative bearing on your benefit. These are very separate matters. You have the benefit you're seeking with USCIS and the court action. And you could have two different attorneys. That's not uncommon. That attorney represents you with USCIS with receipt number 1234, and we represent you in a federal course lawsuit, Newman v. USCIS. And if my lawsuit's dismissed, it's not going to negatively impact your benefit. It will, at worst, go in the normal course and scope of their processing.
So speaking of, what happens in a dismissal, and that, it's not dismissing your case, it's just dismissing the lawsuit. We have a lot of common questions.
Of course.
So I'm going to kind of go through that. And probably a big one is, after you file this lawsuit, do I have to appear in court? I mean, I am suing, and that's what you see in courts is the plaintiff is there and the defendant's there.
Yeah, everybody's sworn in.
Yeah. And the answer is no. Thankfully, in most cases, you don't.
And so these are civil lawsuits. And so unlike criminal cases where you do have to be there, for the most part, you don't have to be in a civil lawsuit unless ordered by the judge or subpoenaed. And it's never happened. Now, I always encourage people, if you're in town and we've got a hearing in your case, show up. It's always good for people to see if they want to. I can tell you we did a delay case, and watching the government try to argue that he's really not harmed if he has to wait another 5 years. But we're not trying to downplay it. Kind of bounce around with the individual there is kind of interesting. So these are typically done on briefs, or if there are in-person hearings, it could just be me as the attorney, or in court, or on Zoom, or whatever. But again, I always encourage people, if they want to go be part of it, great. But I've never had a client required to show up.
All right, another question is, will my name show up in court documents? And so, yes, but kind of limited.
Yeah, so immigration cases, so anytime you file a lawsuit, your name is public information. Now, there are ways, and we saw some attorneys with the seven subdue pseudonyms. My opinion, it tends to slow things down in litigation. But when you look at the docket, your name will appear, and the dockets, everything that we filed will appear. But immigration coded cases, when I file in court, are somewhat sealed, meaning you can only get them if you go to the terminal, the public access terminal. In most courts, nobody even knows where that is, to get the documents. Again, you're suing the government. It's not you being sued for damages. I've never had anybody take anything negative from this.
All right. Well, since I am suing the government, what's stopping them from retaliating against me? What if they just decide they're going to deny my case? Or maybe 10 years from now, they're going to say, ooh, this person sued us. Let's not give them their citizenship.
This is the question everybody asks. Every call that I take on litigation, I head this off at the beginning because it's in every case. Everybody wants to know. I don't want to pay to sue for file a lawsuit, and they're just going to take it out on me. And the answer is no. Not only is it improper, it's illegal. It's not. It rarely happens. Talking with people that used to work for the government, the government agencies aren't organized enough to retaliate, and they are very much separated out. You have this goes through agency counsel, and maybe adjudicators know, but also keep in mind you're suing. You're already in court. You're already standing up to the bully, if you will. And I've had cases where It's been a delay case, and they make a denial that's not a retaliation, but it's a misapplication of law by the field office, and we turn it into a denial lawsuit, and it works out. They're they're not going to take negative action against you. Never seen
All right. Another question is how long does it take
it.
once you file a lawsuit?
Yeah, so once we file the government, we serve them. I always tell clients usually we have them served within about a week of filing. It takes a little bit for the court to issue everything, quality control. Then we got to put it in the mail. And then the government gets 60 days in most cases to respond to the lawsuit. And that doesn't mean things can't happen. It's not uncommon for day 30, day 45 for them to take action, day 50, but they get their 60 days. So I don't start stressing, until I see them file a motion to dismiss, and then we're going to have to oppose it. But um, they know they're on the clock, and a lot of times it's going to be management. Now, sometimes they're going to ask, maybe the deadline's over a holiday and they're going to say, hey, can we get an extra 30 days or whatever? And we're going to be reasonable because they're always going to get that first extension anyway, and we look like jerks. I've needed extensions, maybe I'm sick. So we try to keep a good relationship, but most of the time they're pretty good about that 60 days.
So, 60 days is still kind of a long time.
That
If
is.
you've already been waiting, and maybe because you're waiting, you lose your job or you lose your employment authorization, or maybe you're suing on an H-1B denial where the denial puts you out of status or something like that. That's where maybe a temporary restraining order or TRO could come into play. What is that?
Yeah, so TROs came up big in Sevis. I had people call, I'm going to file a TRO. I'm like, well, let's talk about how we get there. So this is a vernacular people know. This is an emergency order. This is immediate irreparable harm that money cannot cure, meaning money from the defendant can cure. And so if the court doesn't act fast, you're going to be deported. You're going to be, and we can't stop deportation, but we can stop you being unlawfully present, so that you would be. Or like the SEVIS litigation. These kids. We had students who couldn't go take their exam the next week, and so these are. I mean, we're in court within a week if the judge wants to hear a TRO.
All right, but then there's a preliminary injunction, which so TROs are tend to be short, maybe
Yeah,
2 weeks.
14 days maximum unless the parties agree.
And you get a quick hearing and that sort of thing. But a preliminary injunction is takes longer to get, but it also lasts longer. It's basically the court saying during the entire pendency of the case, until we hear on the merits, we are going to block whatever from happening. It's harder to get, takes longer to get as
Mhm.
well because it's not quite as urgent as a TRO, but still powerful.
And it's really just a tactics question. I mean, to be honest with you, we don't file a lot of TROs and preliminary injunctions because we can't always show the immediate irreparable harm. But in the SEVIS cases, that's what we were filing because it was immediate. And we needed some protection. And look, we lost some because the government was in, this doesn't mean anything. SEVIS doesn't mean anything. And so judges are like, there's no harm. There's no immediate irreparable harm. And that's okay with me. Like if you're sitting there saying they're in status and they can work, great. Go to school, great. Like I don't need them orders. So there's what we tend to do with our litigation team is we're going to be strategy focused first, not just guns ablazing.
So, we've talked that using litigation, you can sometimes get an approval faster. Of course, the judge can't force them to approve it, but they can force them to make a decision, which gets you what you are wanting. But what other things can you ask for in court?
Yeah.
Can you get money damages?
No. So, and I get it. This is a question, especially during when we talk about delays of work benefits. You've lost your job. Maybe you're never going to get that opportunity again. Maybe it's caused stress or whatever. And everybody wants to ask, can I sue for all these things? And the general answer is no. The government hasn't waived sovereign immunity over those kind of things where you can get damages in that sense. But depending on how the lawsuit goes, you might be able to get attorney's fees under the Equal Access to Judgment Act if you are a prevailing party on the motions or in the lawsuit, and the government's position was substantially unjustified. You can get damages. Now, in most delay cases, if it resolves during the period before the government, fights it out, or even if they file a motion to dismiss and it works out while everything's pending, we're not a prevailing party. we've gotten what we want, but we're not a prevailing party for Egypt. But when we talk about the SEVIS litigation, where we've won motions and, we're hopefully going to win summary judgment for a couple that we want to push on still, that would be prevailing party. And they're nowhere near justified, right? They've kind of admitted it. So it's always the question. Like, I want, especially with the SEVIS stuff or delays or you've lost your job or can't travel to go to, I mean, God forbid, funerals or weddings or whatever, once in a lifetime things. And as much as that sucks, unfortunately, not something we can do in litigation.
All right, so looking ahead, as you mentioned earlier, we really got into litigation during the first Trump administration with all the things they were doing. Now that Trump's back, we expect litigation to increase dramatically. We've seen this movie before.
We're already seeing it some. We, again, said this litigation never happened before, but we saw during the first Trump administration H-1B approvals spike, L-1 denials spike, most of these improper. And also remember, with some of the stuff happening with Doge, they're retiring or pushing out more senior level people. And so you have more inexperienced adjudicators and they make mistakes or don't understand the law. Um, and so sometimes court is that option. Uh, Processing times, get slower. We're starting to see that. The entry bans, that's being talked about by some lawyers. I've been on some of those meetings. It's a tougher one, but policies. We see because Congress doesn't do anything ever, right? Everything tends to be regulatory or policy memo based in immigration. But they all have to comply with the INA and not go counter to it. So we will see policy challenges. I'm quite confident during this administration.
So yeah, litigation was definitely how we fought back. Federal judges did block unlawful actions, forced adjudications, and helped us restore some sanity to all the craziness. So with a expected kind of climate returning, our litigation toolbox is going to be essential again.
Yeah, it's something, once Trump got elected on, what was it, November 5th, I texted some of my friends in this space and it's like, let's go. Like, we got to be ready for this because it is a tool that we have to be able to use. The administrative options aren't always going to be there. I tell every client that comes to our office, they want to start filing petitions with us. I hope you never have to use our litigation services. And we have a good track record with that. But it is a nice tool to have, whether it's how we draft petitions and responses with an eye towards court, because we control what judges look at, or just knowing how to play the game that they need to play within the context of the administration. But delays are going to happen, denials are going to happen, and the administrative process doesn't always solve it.
Yeah, and with litigation, we definitely don't go it alone. We partner with other attorneys, other law firms who actually specialize in litigation and federal court practice. So you have your immigration expert, you have your litigation expert, and we partner together to get the best strategy and come up with the best way to get the case moving.
And I think it creates a good tool for people, right? I think our firm knows the INA, and I know quite a bit about litigation, but when we work together, sometimes it's a sanity check thing too. I read the statute this way, Emily might read it another way. You got to have more minds in it. But if your case is stuck, don't wait. Push ahead, and there are lawyers who do this. Obviously, we do, but it is a niche field. So make sure you're talking to someone who is competent in this field and knows the immigration, not just I do litigation, because it's very niche doing this area.
Yeah. Well, thanks for joining us again on Visa Vibes. You can find more information on the types of cases that we've already filed and the work that we do in the litigation space on our blog by going to rnlawgroup.com. And we'll see you next time, maybe even from the courtroom steps.